Okay, well, we'll call the meeting back to order. Before we leave this issue that we were just on, you think you feel we should get Pishak in here to see if he's got any interest in?
I mean, it's up to you. I don't know if he could weigh in on it or not, if he's got some ideas around funding or how to help them out. So even if they have to end up with a little bit of a loan, can he work with them in a way that I'm not thinking about? I don't know.
Yeah, we can try to get.
I mean, $1 million is a lot of money if
Yeah,
for that
I mean,
kind of, big
and
bucks.
just Rutland, I mean, there's almost $1 million, and in Essex, it's a
1.5.
1.5. I mean,
Yeah,
those are, I mean, we're talking real dollars here.
yeah,
It isn't like a pocket change. So.
right, especially for these.
Maybe he's got an idea we haven't thought of. I don't know. Mike's pretty,
Yeah,
Yeah.
so we'll try to get him in later this week.
okay.
And,
Be interesting to see.
and,
I mean, the other thing is, although I don't think we're gonna get anything from them, do we just add it to the federal delegation? My gosh, we're dealing with this, but I think with Blakey gone, I don't know how we.
Well, yeah, but Welch is on ag.
Welch is on ag, that's a really good point.
well, they do.
That's a very good point. And could he do something specifically for farm fairs?
This covers a wide spectrum.
Yeah.
From kids to senior citizens to, a lot of people,
Yeah,
that's their.
that's a great
their
point.
holidays.
Yeah, right.
Um,
For some Vermonters, that's their holiday. So you gotta remember,
So, good morning, Michael.
Good morning.
We have the miscellaneous bill.
Yep.
And I think you made all the changes that we've asked for. And thought maybe we could run through that again to make sure everybody's happy with what we have
Sure.
in front of us and then go from there.
Okay. Well, I'll share my screen then.
Today I've got a week of my weekly meeting with the administration.
Yeah, we should be out of here.
Okay, can you see my screen?
Yeah,
Again,
looks
Okay.
good.
All right. Draft 2.2, the first change is that the bill had been first requested by the chair and you asked to make it a committee bill.
Yeah.
So that's a page 1, line 1.
yes.
Then should I just generally walk through each section?
Yeah.
Okay,
Well, lightly.
Yeah. quick.
sure. Section 1's that language that would give the agency the ability to quarantine livestock if they're suspected of having been exposed to biological or chemical agents that may cause adulteration of the milk or other dairy product. Then the next few sections are the update to the egg law, modernizing it. You'll see that the first provisions are what a person shall not do. They can't advertise or label eggs in a false or at least misleading manner. They can't sell, offer for sale, deliver, or donate that do not satisfy the requirements of the chapter. And they can't sell, offer for sale, deliver, or donate eggs that are adulterated. Then you got rid of an obsolete reference to the Division of Business Development in Section 3 in the egg law. Then in Section 4, this is bringing the enforcement provisions and the process for enforcement to a consistency with how the agency and how you have directed the agency to do enforcement, that you prefer that the farmer is issued a written warning, and that describes the alleged violation, identifies this section, identifies the applicable violation, and identifies the required corrective action. Now, this is what the secretary may do if the secretary needs to enforce immediately. The secretary has that authority under its general enforcement authority, but here it's just bringing consistency with how you want farmers to be enforced against, basically given a written warning. And then section 5 is the penalty. This is, you're striking those old penalties amounts and then clarifying.
Pretty old, right, Michael?
Yes, they're very old. And then but what this chapter does is it references the agency's general enforcement authority, that they can appropriate or issue a cease and desist order. They can order under other mandatory corrective actions. They can take enforcement under their enforcement authority, which is Title VI, Chapter 1, and they can seek administrative or civil penalties in accordance with Title VI, Chapter 1, Sections 15, 16, and 17. So those administrative penalties, the maximum is $1,000 for an individual offense. And then if it's an ongoing daily offense, they have a maximum of $25,000. So that's consistent with all the other administrative penalty amounts that the agency issues under Title VI, Chapter 1. Moving on from there, they can issue a verbal order. It doesn't need to be written, provided that they follow up with a written notice. And then a person aggrieved by an enforcement action by the secretary under the egg law may appeal to the civil division of the Superior Court. So it's really just bringing the egg law into kind of a modern process and enforcement requirements. Then you get to the agency's enforcement authority generally. And as I just told you, the current max administrative penalty is $1,000. They're proposing to raise that to $5,000, and they're proposing to raise the ongoing multi-day penalty max from 25 to 50. This is consistent with changes made for ANR's enforcement of water quality. And so what the agency is looking for is consistency with the Agency of Natural Resources Enforcement Authority. So there's not an argument that a farmer is getting or subject to less strict enforcement, including the penalty amounts.
If anybody has questions, just, yeah, okay, Michael.
Okay. Then you go on to the water quality sections. The first is just kind of a technical amendment to the capital assistance program. Last year, there were some changes made to allow for use for greenhouse gases or equipment to mitigate that. And the agency didn't like the language. They didn't like decrease greenhouse gas emissions. They wanted to say mitigate greenhouse gases, because it might not be an emission. It might be some other form of gases. And so that's what they're looking for. It's really kind of a little inside technical change. And then Section 8 and Section 9 refer to the ability of the municipality under its stormwater authority to regulate required agricultural practices. Section 8 provides the municipality cannot exceed ANR's authority to regulate required agricultural practices, that they need to maintain the exemptions in 10 VSR 1264 D1 And D1 is all of the ag and forestry exemptions from operating permits for stormwater. And the municipality cannot charge an operating fee related to exempt practices. And then section 9, which is new, you wanted to clarify that the section 8 exemption for municipal stormwater fees shall apply prospectively and shall not require municipality to refund stormwater operating fees assessed prior to the effective date of the act on properties and activities that are exempt from such fees. So if they assessed it, municipality assessed it and collected it, they don't have to refund it. But going into the future, that farm should not be subject to a fee or regulation.
As of July 1st, correct?
As of July 1, 2023.
Yeah, okay.
You could make those sections effective on passage if you wanted to.
Well, I was just thinking about that. What's the likelihood that a municipality would immediately assess a fee?
In order to,
Beat the deadline.
good question.
I can't really speak to that. It's a possibility, though.
They, see, the listers go out and after town meeting, right? They
Yeah.
list all the properties of the assessors. And then first, they hold hearings. I think July 1 was fine. But they don't get through all the grievances and all of that.
The listers have to log their books for a year in April.
And then after that, they start over, right?
They start over,
So-
but every year, the logging for that year's taxes is done in April.
So,
But remember, this is not necessarily assessed on your property tax. It's not necessarily going through your lister. It's going to be going through potentially the sewer authority, the stormwater utility, just your water authority, because they are the ones that are collecting. In most towns, they're the ones that are collecting the fee.
Well, I'll yield to somebody else's advice, but to me, if we pass it this week, they've got March, April, May, June.
Still has to go to the house, the rest is signed.
yeah, so. But if you
But
start
I know what you
fooling-
mean.
if you start fooling with dates in there and take effect upon passage, it'll raise a lot more questions.
Okay, then I'll yield to your wisdom.
Why are you making this section take effect upon passage?
Yeah, that July 1st.
See, the way it's put together here, it should roll along, I would think, pretty decent.
Okay.
Should we have, just touch base with either Gwen or Karen and just,
Karen,
or and just, I know you're gonna need to, but I think sometimes you better to, not surprise them.
not surprising, we've already had them in.
I know, but we could ask how they assess the. Forget it, I didn't ask anything.
I mean, it's. I think, I think we're in pretty good shape the way we've got it. And you go messing with that, it's, you could stir up a lot of questions.
Okay.
So there are other questions? No. Irene, do you have any questions?
No, it looks good to me.
Yeah.
Thank you.
So are we good to go with this or?
I think so.
I checked in a little bit.
Yeah, I'll do it for her. So I'll move that we vote out draft request 23-0760, draft 2.2.
Is there a second to that?
Second.
Moved and seconded that we vote draft 23-0760, draft 2.2L. Any further discussion? If not, all those in favor, say aye.
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 And those opposed, nay. Motion's carried in the record. Irene, you should make a note that it's 5-0. You've got the sheet.
Well, I can take the load off, Irene, while you're recuperating if you
You
want.
have to take the committee bill to drafting. The chair,
Oh, draft.
to the
Oh,
drafter.
because it
and
doesn't
you-
have a number yet.
Yeah, and you need to give them a clean copy if Michael will send a copy without the highlights.
Yeah.
I'll get that to you and you need to take it to the drafting.
And then we vote.
No, you vote,
Oh, we
you
do,
voted,
okay,
it's done,
okay,
but it has to go to the drafting.
Yeah,
Okay.
because
And
right.
then they'll let you know what number it's given, I believe, and that'll come up on the
Notice calendar.
notice calendar with that number.
Thank you,
Irene,
Mr. Vice Chair. Yes.
is this anything that you aren't gonna be here though, are you?
I won't be back till Friday. I can't because I have to quarantine. So if the Vice Chair would not mind taking that duty, I would really appreciate it. That way we don't hold it up.
Glad to.
Is it,
Thank you.
there's no money in it, right? It doesn't need to go anywhere else.
I probably will not.
It won't have to go to any other committee, do you think?
Right.
Mike?
So technically, the section 7 is amending a funding program, the capital assistance equipment program. But I don't know if the secretary is going to tune into that or not. I would think that it's not that big of a change that requires it to go to appropriations, but you never know.
The only thing I was wondering is section 9.
Yeah, I think that's more of an enforcement provision and less of a revenue issue.
Yeah.
So, but you know, the secretary, it's his discretion to recommend. So I will know for a committee bill, the chair has to turn it into drafting operations.
Yeah.
And you can do that in hard copy or electronic copy. I just sent Linda the draft without highlighting.
Yeah, so Linda will receive that and then I should take it into the drafting room.
Yep, exactly.
So hopefully it'll be on notice Thursday.
I don't know how far behind they are with drafting or not.
Oh,
Well, for a committee bill, it will be,
Should be fast.
it'll either be put on notice tomorrow or put on notice the next day.
Okay.
and Brian called me. So we're all good to go.
And I'll get that copy for you, it's printing right now.
Yeah.
And who's going to be the reporter?
Me, Collmore.
Okay, we're working on a section by section for you, Brian.
Thank you.
Hopefully we'll get it to you as soon as possible.
How's your son, by the way?
He's doing good. He's
Yeah.
doing good.
Good.
Yeah. Thanks.
Well, anything else?
Well, on the agenda was the other bill, but I don't know whether we want to.
Well, the other bill is the nuisance bill.
Yeah.
we've got about 10 or 15 minutes left, Mike. I think that'll give us enough time to get through the other one, or?
I can go through the changes in it,
Yeah.
if you would like.
Yeah, well,
Let me,
0138.
all right.
4.
So Linda, is it up on the committee page yet?
It's not yet, I will put it up.
Okay.
We have it in front of us also.
Do you have the new draft in front of you?
You do if you want to go ahead.
Okay.
The only thing we didn't post it, I'd like, I think the committee should see bills or changes before we cut that loose to the public, in case they get a phone call in regards to a change and they haven't even seen it.
That's a good idea.
I think the committee should see the changes before we pop it open to the
I should do
public.
that in education too. I should do that in education.
Well,
but,
because,
yeah, otherwise
you know,
everybody's gonna get inundated.
they could get a lot of questions and then the committee member says, well, I haven't seen that. I haven't heard about that. It's not fair to the committee.
Right.
Okay, well, since you all have the draft in front of you, it should be draft request 23-138, draft 4.1,
Yeah.
with the date of 2/24/23 and timestamp of 8:37 a.m.
Got it.
As with the last bill, the first change is changing the sponsor from the chair to the committee as a whole. And then I'm just going to talk generally about the rest of the changes. You heard testimony last week that the 1-year provision that was put in the bill was limiting, that it limited people's remedies, and that it made the mediation requirement difficult to achieve within that 1 year. And so, talking with the chair asked to just remove the 1-year provision. But there's still the standard that a farm receives nuisance protection if they are complying with the generally accepted agricultural practices. And what other changes made, and it was the proposal by the agency, and you'll see this change on page 5. The agency wanted to be clear that the plaintiff bringing the nuisance suit was the one that carried the burden of proving that the farmer did not comply with the generally accepted agricultural practice. So on page 5, really it's changing the current standard. There's no longer the 1-year provision. It says no agricultural activity shall be or become a nuisance or trespass when the activity is conducted in accordance with generally accepted agricultural practices, and then a plaintiff alleging that an agricultural activity is a nuisance or trespass shall have the burden of proving by a preponderance of the evidence that the agricultural activity is not conducted in accordance with the generally accepted agricultural practice. So no more 1-year provision, still has a standard that protects the farmer, but the plaintiff still has a remedy. They can reach the courts if they can prove that the farm is not, or the activity is not being conducted in accordance with generally accepted agricultural practices. So there is no remedy removed. There is no time frame in which the remedy needs to be brought. And so I'll just stop there and see if anyone has any questions.
So it's on the plaintiff now, whereas before it wasn't, and the plaintiff, the neighbor would have to prove. And what was it?
So that's a great question, because generally when you, plaintiff brings a claim in tort, they're the one that has to prove the criteria for the award. But
Okay.
in that Airy Point case, the court, and I'm not criticizing the court. I think the court did the best job she probably could have done. The court asked the farmers to basically justify that they were in compliance with the RAPs. And the farmers basically said, well, we have had no enforcement under the RAPs, so we are compliant. And the court said failure to have enforcement is not the same as compliance. So it basically shifted to the farmer the duty to prove that they were compliant. And the farmer had assumed that they were doing everything that they could because they were complying with the RAPs. So this, frankly, just puts the burden back kind of squarely where it should be, that the plaintiff is the one that needs to show that the farmer is not complying.
Well, I think it makes more sense. I mean, the plaintiff, why would you go to court if you thought the farmer was in compliance? The reason you go to court is if you felt your farmer neighbor was not in compliance and acting in good faith. So you have some type of a complaint that you're moving forward with. You know, that was, I don't know, we got pesticides added in, so if they have any drift, the farmer would be in trouble. What about the guy that we had up from Cabot that took the manure and piled it right along the fence line to get his neighbor upset? Now that can't possibly be an accepted ag practice, piling your manure along the fence line.
It likely would violate some of the setback requirements under the RAPs.
So the neighbor that got violated would have action against the farmer for doing something like that, right? I mean,
Right. I mean, they could probably show that. Well, the interesting about that case is that the person piling the manure wasn't a farmer, right?
Yeah, the farmer would have a complaint against the farmer.
So
Neighbor would.
This likely wouldn't have applied to that situation because
Or he moved the cow.
they just say that he doesn't qualify for the protection because he's not an agricultural activities subject to the RAPs.
Yeah.
So under this one, you have to prove, the plaintiff would have to prove that the generally accepted agricultural practices, which, correct me if I'm wrong, Mike, there's no definition, right? They'd have to go out.
No, there is.
Where's the definition of that one?
It starts on page 3 and goes on to page
Okay.
4. It first means the requirements, including the permit requirements of 6 VSA, chapter 215. It then means the requirements of the agency's pesticide rule. And then it means practices conducted in a manner consistent with proper and accepted customs and standards, followed by similar operations of agricultural activities in the state.
And so how does this, so the RAPs are part of the generally accepted agricultural practices? They're
Yes,
sort of in that.
yes.
So, wouldn't it give the court a better direction or something to look at from the plaintiff? If they could take pictures, the law into the judge, wouldn't it be more definite than the way it is now?
Well, I think it's the first two provisions are more definite, the compliance with the RAPs or compliance with the agency's pesticide rule. But you do add on page 4, I should say, line 5, you do add an element of fact finding because the court has to determine whether or not the practice is consistent with proper and accepted customs and standards filed by similar operators of ag activities in the state. So it's that will take some fact finding. That's where you're going to have factual disputes. It'll be easier to determine whether the RAPs were violated or whether the pesticide rules were violated. But subdivision C there, that does insert factual dispute into the standard. But it's also there to maintain a remedy for an injured property owner. If you can show that what they're doing is not consistent with proper and accepted customs, because the RAPs don't cover everything. Remember, the RAPs are an ag water quality provision, and the pesticide rules are about pesticides. You know, there isn't anything in either of those laws about pests. There isn't provisions about your equipment. And so there is opportunity for the allegedly injured property owner to say, hey, this isn't covered by the RAPs or the pesticide rules, but it still shouldn't be protected because it's inconsistent with proper and accepted customs and standards.
But the old law doesn't cover pests either, does it?
Well, it's interesting. One of the provisions of the old law that gets skipped over is page 4, line 15. Right now under the old law, it has to be consistent with good agricultural practices. But good agricultural practices are not the same as the RAPs, because the RAPs are under subdivision A, page 4, line 11, line 13 and 14. So there used to be, under the current law, there still is a standard of what is a good agricultural practice. What you have done is defined what that is and said that's what a plaintiff needs to show is not being met in order to bring that nuisance or trespass claim against the farm.
Irene, did you have a question?
I do. It's really simple, but I'm sorry. I'm wondering on line 4, on page 4, why there's an and rather than an or at the end, and which is a stronger conjunction. Thanks.
Well, and it's a conjunctive, and it means that all 3 subdivisions need to be met.
Right.
That they have to be complying with the RAPs, you have to be compliant with the pesticide rules, and they have to be compliant with accepted customs and standards for the state. So, and means all 3 need to be met, or would only mean that one of the 3 would need to be met.
So it puts more requirement on the farmer.
Yes, and it's also a higher standard of protection, because the plaintiff needs to show that all 3 are not being met instead of just one subdivision is not being met.
Thank you.
Thank you, Mr. Chair. The other thing I'll point out, although we just lost Senator Campion, is the evidence, convincing evidence. So the 3 are preponderance is the least rigorous, if you will, then clear and convincing, and then finally beyond a reasonable doubt. Is that not correct?
That is correct.
So this gives more protection to the neighbor than if it had been clear and convincing or beyond a reasonable doubt. So it kind of, I think it works. Did you hear any of that, Senator Campion? Okay.
That's accurate.
That's accurate.
Any other questions in regards to the changes at this point?
There are a couple more changes.
Yeah, I see, yeah, go on
Page-
to-
Page 6, line 14 and 15, in the required remediation, I talked to one of our judiciary attorneys about how best to address concerns about how the mediation would be conducted. And he said, just cross-reference the requirements of the Uniform Mediation Act, which is in Vermont law at 12 VSA Chapter 194.
I could just take that as sort of a technical correction.
Yeah, and it's just, it provides certainty about what the provisions are that will control the mediation instead of allowing for a person to argue that say information could be used if it wasn't agreed to be used in litigation, things like that.
That's pretty standard,
Yeah.
pretty important.
Right.
And then the next change, if I should move on,
Yeah.
is
I don't see any hands.
page 7, line 1 through 4. You heard testimony last week that it wasn't clear how a person was going to show proof, demonstrate to the court that they attempted mediation. This just provides that a person bringing a court action based on a claim of nuisance or trespass arising from an ag activity shall provide the court with a sworn statement of an attempt to resolve the issue or dispute through mediation. So it's just basically an affidavit that they attempted mediation. And that's really all they would need to do.
So are there questions in regards to the changes to this point?
No, I don't think I have any other questions right now. I'll read through it. Thanks.
Michael, is there anything in the draft that we put together so far that you think, or any parts of what we have before us that should be clarified or changed in any way from a drafting point of view?
Not from a drafting point of view. This has been edited. So it's really about if you want to make substantive policy changes.
And if you compare this with what's on the books today, how would you rate it as, is it more fair to everybody, more fair to the farmer, or more fair to the neighbor, or from?
Well, I would say that it continues to try, or continues to meet the purpose of the chapter, which is to protect farms from nuisance and trespass, while still giving the affected property owner a remedy. It changes the standard that the affected property owner can meet in order to bring the nuisance claim. And quite frankly, it reduces the opportunities that the affected neighboring property owner could argue to defeat the protection. Previously, they just would need to show that the RAPs were not being met, that there had been a significant change, that there, and even if those were met, that they could then show that the presumption could be overcome by showing a substantial adverse effect on health, safety, or welfare, or noxious and significant interference. You have reduced the number of ways that the neighboring property owner, affected property owner, can defeat the nuisance protection, but they still have a remedy. They still have a remedy.
Well, and it's pretty clear and precise, isn't it? If they can show that the farmers abusing a practice and kind of going outside the practice, wouldn't that allow them to come quicker to a resolve?
Well, I think one of the things that will be helpful in resolution is the mediation provision.
Yeah, that's,
If the parties are sincere and try to attempt to resolve their issue through mediation, I think it may reduce the number of arguments or disputes between farms and property owners. So I think it's consistent with what the purpose of the chapter is. It's consistent with other right to farm laws in other states. I don't know what else to say.
yeah. Well, thank you, Michael.
Thank you.
Well, we'll hang on to this and you know, if any of the members of the committee have suggested changes, you know, think about it and look over the what we got in front of us, and we'll go from there. Are there any other comments from members?
Thank you both, or
Yeah.
thanks, actually.
So thank you, Irene and Michael, and we'll